Hi, everyone. Thank you for joining today's webinar presentation, Reducing Patent Costs Using Patent Analytics. I'm Allie Morton, Product Marketing Manager here at LexisNexis IP, and I would like to cover a few housekeeping things before we get started. During the webinar, please feel free to submit questions using the questions feature in the control panel. And also in the control panel, you'll see a handout section. This is where you can access files pertaining to today's webinar, including the webinar slides. A follow-up email of the recording from today's presentation will be sent to you tomorrow. And now I will introduce today's presenters. With us, we have Megan McLaughlin. Megan is the Product Director for LexisNexis Patent Advisor here at LexisNexis IP. After graduating from Harvard Law School, she worked as a patent attorney at the law firm of Nutter, McLennan & Fish. Her technical focus reached into a variety of industries, including medical devices, the food industry, software, printers, and biotech. Also joining us today, we have William Mansfield. Will is the head of consulting and customer success at LexisNexis Patent Site. He's responsible for overseeing the negotiation, creation, and delivery of Patent Site's global consulting projects, along with managing the customer success team. With an economics background and experience in market and R&D strategy in the semiconductor industry, Will approaches patent analytics with an eye on business value creation. Thank you again, everyone, for attending today's presentation. And with that, I will turn it over to you, Megan.
Thanks, Allie, and thank you, everyone, for taking the time out of your day to listen to us. These are some really difficult times, and I think most, if not all of us, are looking for some way to save money right now. And the good news for those of you on this call, assuming that you're on this call because you have a patent portfolio or you're managing one, the good news for you is that we have a way for you to save money on your patent portfolio. Right now, locked in your homes in front of your computer, there's proactive steps that you can take to reduce your patent spend. So the purpose of our presentation today is to prove to you that it's worthwhile to invest time in patent analytics, because this is something you can do right now to reduce your patent costs. Now I'll be speaking to how you can reduce U.S. prosecution costs, and then I'll turn it over to Will at the end so he can talk to you about how to reduce costs on maintenance fees, and his portion is not just limited to the U.S. But before we start, I want to hear from you guys. What are the major obstacles you have right now with regard to budget? So Allie, if you can launch the poll, I want to hear from everyone. Where are you hurting? What is your biggest budget problem right now? Assuming that you have one. And I know a lot of our patent advisor customers right now are struggling in ways that they never have before. They're feeling pinched in ways that they never have before. So I want to know if this is happening to you guys on the call, and if so, if there's a particular area where you feel like it's happening more. So I'll give you guys just a minute to answer the poll question, and then we'll come back to that later to look at the results. All right. So no matter what you answered in our poll, hopefully we're going to be able to address the problem. Because specifically today, we're going to be talking about 5 tips for how you can reduce your prosecution spend. It says in the U.S., but actually the last point is across the board internationally. But specifically in the U.S., we're going to be talking about how you can save money by first understanding the patent examiner that your application has been assigned to and customizing your prosecution strategy accordingly. 2, understanding the law firms that you're using to do your patent work and monitoring them to the extent that you need to. 3, being really proactive and actually targeting your applications to applicant favorable work groups at the USPTO. 4, automatically monitoring for updates in applications that you care about instead of doing that process manually. And 5, strategically limiting spending on maintenance fees. I know that's a huge chunk of the patent budget for a lot of people, so hopefully that'll be relevant to you. I can see, by the way, the poll results came in. It seems like the majority of you on this webinar, your biggest issue is overspending on patent prosecution, not knowing where those prosecution dollars are going. So that's great. I can absolutely show you today how you might save a little bit of money there. And how you can, at a minimum, analyze where your spending is coming from. But to understand in the first place where we're coming from here and how you can save some money, I want to start by helping you understand the extent of the examiner variability that exists at the patent office. So you can really understand why it's important to customize your strategy to the examiner, and why that can help save you money. So I don't think this is the case based on your survey responses, but maybe you don't necessarily think that prosecution budget is your biggest issue, or maybe you just take for granted that prosecution costs are what they are. That's what a patent costs, period. But once you see the big picture of what's happening at the USPTO, you'll see that there's a lot of ways that you could be saving money just by knowing what examiner you're dealing with. So on the slide here is a study that was performed by Dr. Shine Tu from the University of West Virginia Law almost 10 years ago now, but it's equally true today. So he had this notion that some patent examiners were just easier to work with than others. Sometimes he'd file a patent application that he didn't even think was that great, and he'd get an allowance almost immediately. And sometimes he'd file an application that he thought was a slam dunk, and it would languish in prosecution purgatory for 10 years, and he just didn't know why. So he thought, hey, this data is available. Let me be academic about this and really figure out whether what I'm seeing is true. And by the way, around the same time, the inventor of Patent Advisor was thinking the same thing, and that's why Patent Advisor was born, to illuminate this variability. So what Dr. Tu found back then, and it's equally true today, is that the USPTO has two very different types of examiners. There are inefficient examiners who hardly ever grant anything. So he found that about 10% of the examiner pool accounts for almost half of the patents that come out of the office every year. These guys are incredibly efficient patent grantors, probably pushing out between 50 and 100 patents per year. But then on the flip side, there's about 20% of the examiner pool that accounts for less than 1% of patents that come out of the office every year. So the exact opposite, these guys are probably pushing out less than 5 patents per year, and then everything in between. Well, 10 years has passed. This is still true. And moreover, we know that the variability isn't just related to the ultimate outcome. The variability exists in terms of what types of rejections these examiners are making, how they interpret the law. And so really it's across the board, and there's everything in between these two extremes. So seeing this, I'm sure you're probably thinking, okay, well, this makes sense, right? So because we know that some technology areas are more difficult than others, particularly in the US, we know it's really hard to get software patents. So maybe this entire 20% look like this because this was done before Alice, but maybe it's just because software patents are really hard to get. Or maybe it has to do with experience. Maybe this entire 20% of examiners that are really slow, well, maybe it's because they're new, right? And they're still learning the process, and there's just more administrative hurdles in place to allowing patents. So maybe that's the reason. Or heck, maybe it's just application quality. Like maybe these 20% of examiners have some kind of bad luck and are just getting bad applications assigned to them. And so they're not allowing them because they're not novel. But we know from the data that yes, it's some of these things, but it doesn't account for everything. So technology, sure. We know that in 2100 and 3600, where most software applications go, you see a disproportionate number of those inefficient or slow examiners. Those are color-coded red in our patent advisor system, right? So 3600, that's where business methods live. It's got almost 500 red examiners. 2100, where a bunch of other software goes, you've got 230 red examiners. Way fewer in 2800. And actually even fewer in 1600 for biotech and organic chemistry, which is generally kind of a difficult technology center. But technology doesn't completely explain it, because the other thing that you see here is that there's red, green, and yellow examiners in each of these technology centers. By the way, you guys know that the USPTO has 9 technology centers. I just picked these 4 because these are the, quote, easiest and hardest. 2800 is typically the easiest, and these other ones tend to be thought of as the hardest. Just to show you, the extremes. even at the extremes, it's still kind of a lottery. When your application ends up in pretty much any art unit at the USPTO, you're basically you're basically playing the lottery. Now, it's true there are some art units that are all red or inefficient examiners. There are some art units that are all green or efficient examiners. But for the most part, there's fast, medium, and slow examiners in every art unit at the patent office. So, and in terms of experience, absolutely, that makes a difference too. We do know that newer examiners tend to be more slow than experienced examiners, but that's not true every time. Sometimes really experienced examiners are just really, really difficult. And it's a little bit more rare, but I've certainly seen inexperienced examiners who are actually really efficient. So there's exceptions to all those rules. I think when it comes down to it, there's still just a bunch of variability that's caused by different personalities, different interpretations of the law, and different ways that examiners find of making all of their counts. So why does this matter? I mean, the point is this affects everyone. So I did this analysis for a major electronics company that files over 8,000 applications each year at the U.S. I know, it's crazy. I had to recheck that number like 3 times because I thought, really, does any one company file that much? And it does. And what I did was I looked at their applications that had been assigned to green or fast examiners, and I looked at their applications that had been assigned to red or slow examiners just for the last 5 years. And I limited myself to one technology area, so that wouldn't affect anything. And what you see are vastly different results when this same company ends up with one type of examiner versus another. More than double the allowance rate with efficient examiners. It takes a whole extra year to get a patent when you end up with a slow examiner, and about 1.5 extra office actions. And you can imagine, these numbers, they can add up really quickly. I'm sure very few of you on this call have 8,000 filings each year, but even if you have 10 filings each year and you're spending 1.5 extra office action responses and fees with each red examiner, that could add up to a lot of money, especially since this extra money that you're spending on office actions probably isn't even going to get you, it's probably not even going to get you a patent. And I think this analysis is also interesting because it goes to prove that the variability isn't just because of application quality. This is a major player at the U.S. Patent Office. They're not throwing junk at the patent office. They're represented by law firms that are full of brilliant individuals. They have inventors that are really smart and know their space. And even here you see that there's pretty significant variability just based on which examiner that you get assigned. So we've discovered that it's really important to be able to accurately identify which examiners are fast, medium, and slow. And so we came up with our own metric called ETA that is actually predictive of what's going to happen in your application. So this metric actually comes from a study by that same professor, Dr. Shine too. What he discovered is that if you look at the ratio of office actions to allowance in an examiner's portfolio, that's very well correlated with what ends up happening in applications assigned to them. And I'm not talking about the average office actions to allowance. That's a separate metric, right? So some examiners, I think the average U.S. patent examiner takes like between 1 and 2 office actions to allowance. That's average. That's not what ETA is. ETA is actually called examiner time allocation because what it's about is what your examiner is doing every day when they come into work. Are they sitting at their desk and writing rejection after rejection after rejection, or are they sitting at their desk and writing a bunch of allowances? So the ratio is actually, pick up application A, reject. Pick up application B, reject. Pick up application C and allow. That would be an ETA of 2. 2 office actions to 1 allowance. So it's not quite that simple. For example, we've had to adjust for situations where the examiner is new because their ETA can change pretty quickly. We know when an examiner's ETA is changing, and so we try to smooth for that and account for that. But in general, that's how you can think of the ETA. And the ranges are basically based on the bell curve, right? So most examiners do fall into this yellow or middle range of an ETA having 2.6 to 6. About 25% fall into, this slide should be reversed. About 25% are green, which means they have a very low ETA, and about 25% are red, which means they have a very high ETA. So this should actually be reversed. But you get the idea. Basically, a red examiner means stop. Prosecution is going to be tough. Green means go. And yellow is just about average. And then, of course, we'll tell you where that examiner falls with respect to their art unit. So this particular examiner on the page, they have an ETA of 2.8, which is in the yellow zone, but they're actually pretty quick for the art unit that they're in. So if you were thinking of filing a pre-appeal or something like that, I don't know how well that would go for you, because you actually ended up with an examiner that's fairly easy for their art unit. So I recognize that was a pretty long lead into the first tip, which is just knowing your examiner and customizing prosecution strategy to them. But I wanted you to understand why this is so important. And it's because there is such significant variability at the patent office. And if you know that, you're going to drastically change your strategy if you know that you've ended up with a red examiner. Because a red or inefficient examiner, they're not just slow, they're really slow, maybe granting less than 5 patents per year. So if you've got an application with a red examiner, maybe you're 2 or 3 office actions in, case doesn't even matter that much to you, do you really want to continue prosecution of that application? ETA can even inform whether you want to file an application in the first place, right? We know from what I showed you about the tech centers, every tech center group, every art unit has its own division, its own distribution of red, green, and yellow examiners. So if you're going into a particular art unit, what your likelihood is of getting a red, green, or yellow examiner. And if you're overwhelmingly likely to end up with a red examiner, do you even really want to file that application in the U.S.? I don't know, maybe not, but it's an important piece of information that could help you make that decision. So if you do nothing else, just look at this one metric. We've designed it to be incredibly predictive of what's going to happen in your application, because it turns out that knowing who your examiner is very predictive of what's going to happen in the application. So if you do nothing else, just look at who the examiner is when you're making any of the 10, 100 decisions that you make each day with respect to a patent. Because if you don't, you can end up in a situation like this. Now, I don't know this application. I don't know what the situation was. Maybe the examiner was being really difficult and it was actually like the best patent and it really should have. And by the way, it did end up getting patented after 16 years. But it took 16 years. Looks like it took about 17 office actions. I don't know how many RCEs and an appeal. And the fact is, this examiner's ETA was almost 40. And remember, over 6 is actually in the red zone. So any ETA over 6 we consider to be in the red zone, which means incredibly difficult. And this examiner had an ETA of 40, which means that from the day that this examiner got assigned, the day that this application got assigned to the examiner, it was completely predictable what was going to happen. So we can help you avoid investments like this that may not pay off. And finally, everything I've been talking about up to this point, it's about making decisions about an individual application, but you can do this analysis on your whole portfolio. So Patent Advisor has tools to help you break down your portfolio by ETA. So for this example portfolio shown on the screen, 3 pending applications are with green examiners, 19 are with yellow, and yikes, the whole 49 are with red examiners. So these 49 applications, which you can identify, are immediate candidates for pruning. If you map these applications to their business value, any application with a red examiner and low business value, that's cost cutting right there. That's probably the very first thing to go on the chopping block. And then conversely, anything that's with a green examiner that has high business value, fantastic. Capitalize on your advantage and file a continuation there. And you'll probably get a patent for way less money than you would have continued to pay on one of these red applications down here. So in conclusion, you need to know who your examiner is. It'll inform your strategy in a really meaningful way, and it takes literally 2 seconds to look at the ETA. It'll help you avoid bad investments. All right, so the next tip, reviewing and monitoring your outside counsel. So just like some examiners operate more efficiently, some lawyers operate more efficiently and effectively than others, and we can measure that. So this graph that you're looking at right now, this is just an example. I honestly don't even remember what company I ran this for. But it's just an example of a company in a particular technology area and the law firms that work for them. So the y-axis here, you can think of as effectiveness. How good is this law firm at getting patents? And we've just chosen to measure this using allowance rate here. So obviously you want to be you want to be as high up on here as you can be. And the x-axis here is efficiency. How quickly does this law firm get patents? And you'll actually notice that that the numbers are reversed, and that's because obviously it's good to have a low time to allowance. So overall, you want to be where this law firm is. You want to be in the upper right-hand corner, solidly in the green zone, which means that you're better than average in terms of effectiveness and efficiency. You don't want to be in the red zone, because that means you're worse than average in terms of efficiency and effectiveness. So, and the size of the bubble, of course, represents the number of applications that each of these law firms is handling. So you can imagine why this information is really important. If you know which law firms are not operating at peak effectiveness or efficiency, you can work with them to improve their processes. You can circle back with them, stay on top of them, do whatever it takes to help them get up there in the green zone. And likewise, if you see a standout law firm that maybe you're not giving that many applications to, maybe you should be funneling more work their way, because maybe they're actually getting you better bang for your buck. But there's a really important caveat here, and that has to do with the x-axis that I have. Now, I've shown this just for the sake of illustration, but it can be a little bit misleading to just look at something like time to allowance or number of office actions to allowance, because as you saw from the first 20 minutes of this presentation, there is extreme variability in terms of the examiners at the patent office. And so it's entirely possible that one law firm, I don't know, just had bad luck and ended up getting a ton of applications with a red examiner, or maybe they just got assigned, a single patent family, and that family was with a red examiner. Well, that could actually make it seem like their time to allowance is way longer than it should be. So we've come up with a metric to help you normalize for examiner difficulty, and we call it the Patent Advisor Efficiency Score. Specifically, what we do is we score every application against what we think is par for the course for the examiner to which the application was assigned. So for example, if you get assigned to a red examiner, and this is just for the sake of illustration, these are not actually what we think is par for the course for these examiners. We expect you to bring the case to resolution within 3 office actions and 1 RCE. And by the way, we have different standards for patented and abandoned cases. We're actually a little bit more lenient with abandoned cases, because we expect it'll take you a little bit more time to decide that you want to cut the cord. And then, of course, we're going to be really stringent with cases that were assigned to green examiners, because these are examiners that want to push the application through quickly. They want to bring you to allowance. They want to work with you. So if you're taking a really long time with one of those examiners, we're going to ding you for that. So in this system, the very same application prosecution path could get a different score if it were with a red or a green examiner. So in this particular example, very standard prosecution, 3 office actions and 1 RCEs, and it got issued. Well, if this was a red examiner, this is awesome. Standout job. We're going to give you top marks here. But if this was a green examiner, we're actually not going to give you a great score for this, particularly if this examiner, on average grants cases after like 1.5 office actions. This wasn't a great result. So we average all of the scores for each application, and that is the efficiency score. We can calculate efficiency scores for law firms relevant to this situation, but we can also do it for corporations. It's a beautiful thing because it's normalized for examiner difficulty. It's normalized for the number of applications. We can give you a relevant metric whether you have 2 applications or 8,000. And there's no direct penalty for abandonments, which I think is really important. A lot of the times, law firms aren't abandoning cases because they failed. Sometimes it's because they couldn't come to an agreement with the examiner. A lot of times it's because the client said to abandon it because they changed course. And so we don't want to penalize law firms for that. What we will do is we will penalize law firms if there was an abandonment after years and years of extensive prosecution. But we won't penalize directly for abandonments, which is what allowance rate does. And I know allowance rate is a metric that a lot of people rely on. So what you'll notice if we instead change this x-axis from just time to allowance to efficiency score is that you'll see these bubbles move around a lot. So as you can see, here's time to allowance. This firm is in the green area. Everybody else is, somewhere in the red zone in terms of efficiency. Oops, sorry. But then when I normalize for examiner difficulty, actually everybody moves over into the red zone. And Baker, this firm in particular, moved really far over from the right to the left, which means that maybe the reason that some of these firms look so good was that they actually had pretty good luck with the examiners they were assigned to. But when you take that variable out of the equation, things can look very different. So in conclusion, really important to review your outside counsel. You can even monitor for specific prosecution patterns that you're concerned about, like, I want to monitor for every time a case with this law firm exceeds 2 office actions and 1 RCE, so I can check in with the law firm. Whatever you see to be a problem based on this type of benchmarking, then you can monitor going forward so you can work with your outside counsel and help them get more efficient and effective results. All right, so thus far we've just kind of assumed that the examiner you get is the examiner you get. And if you get a red examiner, that sucks, but you can move forward with it, right? There's strategies that you can take. Maybe you want to appeal the case. Maybe you just want to abandon the case, and so that you can reduce your costs that way. But you can actually be much more proactive about this process. And so in terms of saving money, this might actually be the most important tip, because it's once you're assigned to a red examiner, if you really have to continue prosecution of that case because it's important to your business, it's gonna suck money. Unless you have the most novel thing in the world or just the most personable and brilliant attorneys, it's gonna cost a lot of money. You'll save the most money if you can avoid ending up with a red examiner in the first place. And it's obviously not going to be possible every time, but sometimes it is. So specifically, what we're suggesting that you do is that you recharacterize your invention to make it more appropriate for review by a different group of examiners. So from what we know of the patent classification process, it's largely manual, right? When you file an application, it goes off to the classification contractor. The USPTO's classification contractor is made up of highly sophisticated individuals who will read through your application and then assign a USPC code that then routes it to an art unit. This person is an expert. They've been looking at these applications for years. Maybe they even have an advanced degree in the area that they're classifying. So you're not going to fool them by changing a word around here or there. You really need to recharacterize the invention, because we know that some art units are just more favorable than others, right? Like I showed you very early on, every technology center has some distribution of red, yellow, and green examiners. Almost every art unit has some distribution of red, yellow, and green examiners, which means there's some chance that you'll end up with a red, yellow, or green examiner. Now, the good news is there's always a disproportionately high chance that you're going to end up with a green examiner because of the way that they work. Because they work quickly, they have more open spaces on their dockets that you could possibly fill, right? That's just how they operate. They grant more patents quickly, which means spaces open up on their docket more quickly. Red examiners tend to hold on to cases for longer, which means that they may not have as many spaces open on their docket. So what we did was we came up with a lottery map to figure out your chances of ending up with a red, yellow, or green examiner in the event that you're assigned to a particular group of examiners. And specifically what we did was we multiplied the number of examiners by the number of, what we actually do is we look at the number of dispositions coming out of each group every year. So 52.55% of dispositions that came out of this art unit came from only 33.3% of the examiners that were green. So that's how we figured that out. And it's a really good way for you to understand, if you end up someplace, kind of what are your odds? And even if you can't change the course of the application, at least you know, so you can put it in your budget in advance. You can warn upper management, hey, if you really want to pursue this, that's great, but it is going to cost more money. So let us know what you think about that. So I'll give you an example. You can do this on your own, obviously. If you're used to working in a particular technology space, maybe you know how to, what your other options are and how you would craft your application. But I don't think many attorneys are doing that at the moment, and so we have tools to help. So first we have an automated tool called Pathways, which is basically a classification engine that guesses which technology center group your application is likely to be assigned to based on the technology and the claims that you input into the system. So what this is showing is the input claim is for some bone implant that's got a drug on it, and the drug is released into the body over time, right? So Pathways tells us, okay, it's got a 57% chance of ending up in 1610, which is kind of a difficult group of examiners. It's almost a 50% chance of ending up with a red examiner, basically no chance of ending up with a green examiner. But there's also a 13% chance based on this text that it could end up in a group called 37D, which is a mixture of art units that we came up with based on the technology that we found to be in them. And there, you're overwhelmingly likely to get yellow, but you have a much better chance of getting green and a much smaller chance of getting red. So what Pathways can do is when you decide to target a particular group and avoid another, is it'll produce customized drafting guidance for you based on your input text. So specifically what it's doing is it's finding words in your input text that are likely to influence classification in a direction that you want to go, and then words that are likely to influence classification in a direction that you don't want to go. So, and then of course each word has a weight, which indicates how influential that word is in the classification decision. So in this case, like I said at the beginning, word substitution will get you nowhere. Nobody's going to read your application and be fooled by that. What this is meant to do is to help you understand, okay, everything related to the hardware, the implant itself will help me, and everything related to the drug will hurt me. So I rewrote the claim. Now it's a method for treating a patient. It's about implanting a hardware device that, oh, by the way, like has a drug on it. And now I'm overwhelmingly likely to go to the group that I wanted to. In the event that you need a little bit more guidance or maybe a higher degree of specificity, because the algorithm can only categorize down to the technology center group level, it can't go all the way down to an art unit. The types of questions that you need to ask to make those decisions, is it going to go to 2811 or 2812, are very complex and subtle. And frankly, I'm not aware that there's technology out there that can do it. So what we did was we actually partnered with the classification experts at Serco. And so we have an agreement with them where before you file an application, you can send it over to Serco and they'll have someone look at it and give you a classification opinion. They are incredibly accurate, 95% plus, and they can go all the way down to the art unit level. They'll even talk to you on the phone and help you understand how you could classify or why they made the classification decision they did, so you could understand how you might be able to change that. So just so you know, you can, obviously you'd want to use this with any original filing. It's just a best practice to throw it into Pathways. It only takes 2 seconds. But I've even seen customers move an application to a different art unit or even tech center group on a continuation application. Obviously, it's going to take some more significant changes to the claims, and you had to have had that in the application in the first place unless you want to file a CIP. But I've seen customers do this with just a straight continuation. So it is possible to even change your examiner by filing a continuation with these processes, although probably definitely a little bit harder than if you were just filing, doing an original filing. All right, so the last cost-cutting tip on the U.S. prosecution side is a pretty straightforward one. You should automatically monitor for application updates. When I was an associate, and I was not an associate for terribly long, but when I was a junior associate, I remember I had a list of applications that I was supposed to go through every morning. So it's my workflow. I'd get to work, get my first cup of coffee out of 10 for that day. I'd sit down and I'd go into PAIR, everyone's favorite user experience, and prove to it that I was a human. And then I would pull down, 3 or 4 or 5, who knows, it differed, applications to see if there'd been an update, because some clients of mine wanted to know about it. Don't be like my old clients. There's no reason that you have to pay an associate to do this. We can do this for you automatically, and we can do it at pretty low cost. All you have to do is just give us the application numbers that you want to watch, and we'll track for any type of patent event that you're interested in. Is there an office action, an amendment, an issuance, whatever. We'll send you the documents directly in an email so you can open them up. You can look at the documents directly from the email. You can share them with other people. And we'll even monitor the continuity data tab. So we'll let you know if there are child continuity applications, and we can monitor those too. So this one's a really, really easy one. Just feed us a list of application numbers and we'll save you those additional billables coming from the junior associates who probably didn't want to be doing it anyway, not to speak for anyone else. So to sum up, from my part, hopefully I've convinced you that you can save money by adopting at least one of the strategies I've talked about. So know who your examiner is, understand how your law firms are performing so you can work with them and monitor them to the extent that you need to. Target your applications to favorable art units, not just original filings, but continuations. And don't be spending money to have associates checking on applications for you. That doesn't have to be a manual process. Save the time, save the money for more important patent lawyer tasks. So with that, I will turn it over to Will to talk about how you can save money on annuity fees, and not just in the US.
Thanks very much, Megan. It's always great to look at ETA. It's always really interesting to see, how much power there is, how much information that can reveal about what's going on. It must be, I think it must be a real struggle for people to be applying for patents without that information at hand. And so the other part of that, once we've gone beyond the prosecution, then is the ongoing maintenance fees that we have to pay for patents. And we were having a conversation before this started about budgets being tighter as well, and even within our company, looking at the patent portfolio and saying, okay, do we need to spend this much money there? When in the past, for years and years, no one has ever questioned that. So now these people are looking at this. We need to have a way of saying, okay, we are spending money in the right place, or there are places where we can save some of this. So I've tried to take an example that's appropriate compared to what Megan just showed. So I thought I'd take Becton Dickinson as an example, and we just have 3 examples looking at how we can identify cost saving in the ongoing annuity fee costs for their portfolio. So similar to the way that Patent Advisor has ETA, this metric that's generating all this insight that Megan has shown. In Patent Sight, we have a metric that then allows us to understand what is the technological strength of the patent. And we've done whole webinars of an hour or more just going through the real detail of this, and they're available. They're on our website. So if anyone's interested to learn more, please go and look or reach out to us directly. But nevertheless, this metric is on the bottom of the diagram here, competitive impact. And we group this into 10 different groups in this. So we take the whole database, all patents in the world, and say, okay, these are the patents with the highest competitive impact. Those are the 10, and these are the patents with the lowest competitive impact. This is the 1. And then we map the others in between here. So we have the 1, which is the bottom 10%, 2, which is the next 10 to 20%, and 10 is the top 10%. And 10, those are the world-class patents. 9, these are still good, above average. 8, this is where the average for the whole database is. So anything 7 or below, this is below average competitive impact. These are the patents which don't seem to have a noticeable technological strength. Of course, there can be other reasons to file for and maintain patents. But if we want to look at cost saving potential and we don't want to go through the entire portfolio of thousands and thousands, then we need somewhere to start. And starting with those that appear to have no technological value or limited technological value and innovation, then this is a place that we can start. And just looking at the Becton Dickinson portfolio, we can identify these 743 patents that are in these below average deciles, this 1 to 7. And these patents in 2021, they're going to cost Becton Dickinson $1.3 million US to maintain. So just next year, they're going to cost more than $1 million to maintain. And these are patents with a questionable technological strength. And like we say, there can be a reason to maintain these, but even if we reviewed 50% of these, even if we reviewed 25% of that's 250, more than 250,000 US dollars every year we're going to save just from doing that. Because they're not just going to cost 1.3 million next year, they're going to cost 23 million over their natural lifetime, over their 20 years, whatever it is for all of those individual rights. It's going to cost 23 million to maintain them over that period of time. So there's a huge opportunity in here to identify potential, and in even small, medium-sized companies, there is still a huge potential to identify saving by just looking at, okay, what is the most low-hanging fruit out of all of this? And that's one way we can look at the data, and like I say, the metrics, we can talk about how those are calculated, but there are other ways that we can look at this and identify cost saving potential as well. So maybe this is a reasonable distribution. Maybe Becton Dickinson is a typical player within their field. Maybe they're spending as much as everyone else. But if we go to the next slide, then we can see Becton Dickinson compared to the rest of their field. And we've just picked some other example companies that we can compare to. So Becton Dickinson is there, Boston Scientific, Abbott Laboratories, and Edwards Life Sciences. And the gray bar here, this is the patents, so the number of patent families within their portfolio. So we can see the Boston Scientific, the Abbott, they have a similar size portfolio, about 6,000-7,000. Edwards is much smaller. But the ratio of cost to number of patents for Boston Scientific, for Abbott, for Edwards is pretty similar. So the annuity fees and the portfolio size, they're not on the same scale, but nevertheless, the bars are pretty much lining up in each case. But for Becton Dickinson, we can see that actually the blue bar, the cost side, is almost double that of the gray bar, the number of patent families. In fact, so it seems that they're paying more than double for each family than Abbott is, or Boston Scientific, or Edwards Life Sciences. So it seems that they're not typical in their field. If these are appropriate comparators, then it seems that there must be some pruning potential. And this is then going beyond looking at those low value patents that we looked at in the last analysis. If we would just reduce whole patent families, the gray bar and the blue bar would both move to the left. Everything would move down, and we would still have this ratio between the blue and the gray bar. So it's very likely that Becton Dickinson is protecting more broadly for more patents than their peers. So we can drill into this as well, and then see in the next slide where they're really spending their money. And so this is then looking at the annuity fees and where these companies are paying. So unsurprisingly, there is this huge bubble in the US. Boston Scientific, Abbott Laboratories, they're protecting majority of their portfolio, and the majority of their costs are in the US. This is pretty similar for Edwards, although it seems that they're protecting quite a sizable amount in Germany. The ratio of US to Germany is very similar, and they still have a lot pending at the EPO. But Becton Dickinson, they seem to be protecting very, very broadly. I mean, if we see Boston Scientific, they have vastly more cost in the US. But if we go down to a country like France or Italy, we can see that Boston Scientific is spending less than Becton Dickinson. So even though they have a bigger portfolio, even though they have twice the size of the portfolio as Becton Dickinson, and twice the cost, they're still spending less in these other countries where it's maybe not efficient to maintain it there. Is it producing value to have it there? And actually, Becton Dickinson is spending about 600,000. So you can't read the bottom of my note, but Becton Dickinson is spending about 600,000 in Italy, and Boston Scientific about 300. So if we normalize that, if we just changed the protection strategy to mimic that of our peers or that of Becton Dickinson's peers, then in Italy alone, they would save 300,000 in 2021 alone. And obviously that's then a continual saving for years and years and years. So when we have the power, when we have the information at hand, when we're able to do these simple analyses that show us, okay, where are we spending our money? What is it that's really costing this? What is it that's likely to cost more money? Then we can really quickly see, okay, something's going on here. We're not maybe as efficient as we should be. I mean, there may be a very good reason to protect in Italy strategically, but also in France and the United Kingdom, this becomes hard to believe that this is an effective strategy, and maybe then it needs to be reviewed. And if we do that, there is this huge potential in the hundreds or thousands or millions every single year for these medium, large size companies.
Yeah, I mean, Will, you put my presentation to shame, because the dollar amounts here with these annuity fees are just astronomical.
It's crazy, right?
Yeah, I don't know what the
Samsung,
statistics
for example,
are, but I think you can pay. Yeah, go ahead.
Samsung is spending 111 million every year on annuity fees. That's not lawyer fees, that's not prosecution, that's not like all the in-house stuff, that's just money to the patent office. 111 million every year. And I know Samsung is a big company, but even, you know, if you saved 1%, if you managed to make 1% more efficient, you'd save $1 million every year. And
yeah,
you know, I don't think anyone could say that's a bad idea. If I walked into Samsung and said, you know, you can pay my salary for a year and I'll save you $1 million, they're probably going to say yes, right?
Right. And it's the same story with the prosecution analytics. I mean, when I see an application that's gone way off the rails, like the one I showed earlier, I don't know why it went off the rails. Maybe that's the most important application the company owns, and they were going to pay whatever it took to get that, and that's fine. We're just about illuminating these trends so that you can see them and make appropriate decisions. Like Will said, maybe you really need to maybe Becton Dickinson really needs coverage in Italy. Who knows? But the point is, we can tell you that. So you can try and make the best strategic decision. The data is just one piece of information, but it's a really crucial piece of information, especially if you don't have it.
And that's it. It's about making these decisions knowingly, right? Not falling into a situation of spending a lot of money on something unnecessarily, but making it for the best reason possible.
Right. Right. So unless there are any questions, I don't see any, but Allie, maybe.
Oh yeah, I can see the questions, but do you want to do the poll real quick before we get into the questions?
Oh, right. Good point. All right. So now that we've provided you guys some tips on how you might be able to save some money using patent analytics, I'm really interested to know what you guys think would be the most useful of the things that we've shared today, or what you think that you're actually going to take away and use in your day-to-day workflow. All right, so I can see we're still in progress, but it looks like tip number 1 and tip number 5 are winning so far. So the very first and the last thing, that's great. We started strong and we ended strong. And by the way, I think that tips 1 and 5, so customizing prosecution strategy to your examiner and strategically limiting spending on maintenance fees, I do think those are going to be some of the best ways to lower your costs. You know, targeting your application is probably the best way to lower costs when you can. You want to avoid getting sucked into the black hole that is dealing with an inefficient examiner, but it's not always possible to do that. It's almost always possible to design a better prosecution strategy just by knowing who your examiner is. So you can make a wider impact with that. So that's interesting. And then I'm not able to see the questions. Allie and Will, can you help out there?
Them. Yep.
Sure.
So one of the questions that came in is, if I discover an application that's with a red examiner, what are my options for getting it in front of another examiner?
Yeah. So good question. it's really, really hard to just file a petition for a new examiner. It pretty much never happens. So your only hope would be by filing a continuation. So one strategy that I've seen people use without analytics is just file a new application using track 1, particularly if you know that your application is currently with a fairly inexperienced examiner. It seems like in my experience, the USPTO gives track 1 cases to more experienced examiners because they have to move fast, right? That's the whole point of track 1. So you could do that, although I guess you'd still need analytics to know whether your application is currently with a junior examiner. But then there's this targeted drafting procedure that I mentioned. So you probably really have to do some surgery on the claims. I think there's a presumption that when you file a continuation, it's probably going to go to the same examiner for reasons that make a ton of sense to all of us. The examiner knows the subject matter. Why would you give it to somebody new? But if the claims really are directed to a different technology area, the USPTO should direct it to that technology area.
Okay, let's see. Another one that came in is, are there plans to offer this kind of analysis or tool about other offices, in particular the European Patent Office?
Yeah, I can't speak to that personally. That's over my head. But it's a really good question. I'd be interested to know whether the same type of variability that exists here exists at the European office. So whoever asked that question, if you can email me and let me know if you think that the variability does exist there, I'd be really interested to know. I worked very little with the EPO when I was practicing, so I don't have much experience with it.
And there are a lot of questions, so if we don't get to all of them, just know that we'll follow up with you via email afterward to make sure that your questions are answered if we don't address it in the last few minutes we have here. Another question is, can the efficiency score target outside counsel's handling of a specific applicant's cases?
Oh yeah, absolutely. We can produce that score for any data set. So you could limit it, you could look at just the cases that a law firm worked on for a particular client. You could even then limit it to a time range. So, in the past 5 years or in the technology space. Yeah, pretty much you can look at that score for any subset of factors that you're interested in.
Another one is the example that you gave with the company with 8,000 plus filings. Was the variability due to the different tech centers and art units, or, well, actually it just ends there.
Yeah, so I actually limited that example to Technology Center 2100, which, even in itself, it has a fair bit of variability. So that's still fair. Maybe there were some technology differences even within 2100. But I've done a similar analysis before at an even narrower scope. So like for a particular art unit, and you still see differences in the results. Maybe not as drastic, but you will. And whoever asked that question, I'd be happy to do that analysis for you, your company, your firm, for a particular art unit if you're interested.
Okay, another question is, how is ETA different than allowance rate?
Yep. So I could spend a whole webinar on this one. When you spend your days dealing with patent data, you start to get emotional about these metrics. I don't know how I reached this point in my life, but allowance rate just makes me angry. I know that it's throughout Patent Advisor, and it's not like we're going to stop publishing allowance rate because it's obviously important. But so allowance rate, as we've defined it, is just patented cases divided by patented cases plus abandoned cases. Kind of like, what's the percent chance that your application is going to get allowed versus abandoned? And like it's a good indicator, particularly for an examiner, right? If the examiner is really slow, over time their allowance rate is going to start to look bad because applicants are going to give up on their applications with that examiner. But it's a lagging indicator. It takes a while for an examiner's slow behavior to end up to show up in their allowance rate. For new examiners in particular, it could take 3 to 5 years for that examiner's allowance rate to show you anything meaningful because you have a major small numbers problem, right? Like it takes 3 to 5 years to get a patent. So they're not even going to have patented or abandoned cases for a while. It also doesn't reflect the examiner's pending portfolio, which again is a big problem with new examiners, right? So when an examiner starts at the U.S. Patent Office, they have sometimes they get dockets of between 50 and 100 cases assigned to them immediately. And it takes them a while to get through those cases. So they could just be churning through those cases, issuing rejection after rejection after rejection, and their allowance rate could be something decent, maybe they allowed 2 of those cases, and so it looks like their allowance rate is 100%. But really what you don't see is that they're just churning through tons of pending cases. And finally, and this becomes a real problem, I think, when you're measuring law firms in particular, it penalizes for abandonment. So abandonment is in the denominator. It's it assumes that an abandonment is always a bad thing. I think an abandonment can be a really good thing. It's an indication that you decided it was time to cut your losses and go. And I think that if you're, savvy applicants actually will abandon when necessary, either because the business isn't interested anymore or because it's just pointless to move forward with the examiner and waste their money. So ETA accounts for all of those problems. It's the ratio of office actions to allowances. So it's based on the examiner's behavior. What are they doing? Not is there an abandonment, but what's the examiner, him or herself, actually doing every day when they come into work? Are they writing rejections or are they allowing cases? And if they're spending the majority of their day writing rejections, that ETA is going to be really high. And it's going to show up in the ETA immediately. If an examiner has only been there for a year, they may have written 100, 200 rejections and maybe only issued 2 or 3 allowances. Our ETA score will show you that they're doing that. Their allowance rate could be 100%. In fact, will likely be 100%, but their ETA could be something like 80. So that'll tell you what's really happening and what your chances are with that examiner. We've also done regression testing with ETA, so we know that it is predictive. Allowance rate isn't predictive to the same degree. I know that was a long-winded answer. I'm passionate about that one.
No, completely understandable. So the next question, I think actually these next 2, I can just go ahead and answer. The one question was about during Will's presentation, where to find that webinar that goes more in depth around the patent asset index. We will include a link to that webinar in the follow-up email so that everybody has access to that and you don't have to go hunting to find it. And then the other question I see here is, I dialed in late to the presentation. Will the recording be emailed out? Yes, we will be sending out a follow-up email to everybody who registered for today's webinar and include the recording as well as the slides and links to other helpful information that was addressed during today's presentation. That is all of the questions that I have seen come in so far. So let me go ahead and then Megan, you can put it on the last slide. For anybody that has any follow-up questions, please feel free to reach out to Morgan. You can also see here the URLs for all of the different products that were mentioned today, so feel free to go out there and take a look. And thank you again so much to Megan and Will for your great presentation, and thank you to everybody who attended today.
Thanks, everyone. Take care and be safe.
Thanks very much, guys.
Bye.